Today's tips can help you avoid the top 3 things that complicate the sale of a home that's occupied by a tenant. The very first question to ask an owner who's listing a tenant-occupied property is whether they've ever had a written lease agreement with their tenant. If they have, that lease should be reviewed to determine things like whether the tenant has an option to purchase the property or to renew the lease after the initial term. The tenant has the right to stay in the property for the duration of their agreement with the initial landlord. But what happens if the tenant refuses to leave? Having to evict a tenant who won't leave is the first of our top 3 things that complicate the sale of a tenant-occupied home. The best way to avoid this issue is to confirm what you have found out about the lease terms, not only with the landlord, but with the tenant. And in the event that a potential buyer would prefer that the tenant leave even sooner than the end of the lease, an agreement, sometimes called cash for keys, can be reached and be put into writing. A tip for buyers who are making an offer on a tenant-occupied home is to make sure that the sale and purchase contract indicates that the property is subject to a lease or occupancy after the closing. In the most recent version of the as-is contract approved by the Florida Association of Realtors and Florida Bar, Paragraph 6B should be checked to allow the buyer an opportunity to review the lease terms to determine whether they're acceptable. Having direct communication and building a rapport with the tenant will also help to combat issue number 2, which is accessing the property for showings with potential buyers. Florida law states that a tenant cannot unreasonably withhold consent for the landlord or their agents to enter the property from time to time for things like showings, but it's much more effective to come up with a schedule that works for the tenant in advance rather than springing a showing request on them the day before. The third thing that can complicate the sale of a tenant-occupied home is how the security deposit and last month's rent are handled. To avoid any confusion, the title company handling the closing should have a form called a tenant estoppel filled out and signed by the landlord and the tenant, confirming the exact amount being held by the landlord and for what purpose it's being held. These funds will then be credited to the buyer on the settlement statement so that when the lease term comes to an end, the new landlord can apply the funds for their intended purpose and the seller leaves the closing with no further responsibility to the tenant. If the property is also located within a condo or homeowners association, it's a good idea to check with the association to see if a separate deposit is being held by them as security for any potential damage to the common elements, and if so, who gets that deposit at the end of the lease. An association may also have rental restrictions that apply to the new owner. Although a current lease cannot be disturbed, the new owner may be prohibited from renewing that lease with the existing tenant. So a thorough review of the rules governing the association is recommended. To discuss having an attorney help you review an existing lease or the association's rules, send a text to 561-225-2676 to set up a time to speak with me.